Good day. Welcome to another episode of Off the Record. This episode today is a little bit different in the sense that Unathi will not be hosting, I will be hosting, and Unathi will be my guest. Unathi Dlamini is an associate with Shepson & Wiley Attorneys in our Employment and Social Media Law Department. Unathi is an avid public speaker where she shares her knowledge and experience and loves posting on social media. Welcome, Unathi.
Thank you so much, Deirdre.
Today we are going to talk about the recent seminal judgment of the Constitutional Court, the Van Wyk judgment, which dealt with maternity leave and in particular Section 25 of the Basic Conditions of Employment Act. Unathi, just off the record, share with us, why did the Van Wyks approach the courts?
So this was a groundbreaking judgment for a number of reasons. And I think with the Van Wyks in particular, they were a good couple, so to speak, to approach the court because their family structure wasn't conventional. So Mrs. Van Wyk had her own business and they decided that it would be best for the parental unit if she goes back to work. And Mr. Van Wyk assumes the primary responsibility of caring for their child. However, as the law stood at that time, Mr. Van Wyk didn't have the leave available to him. He only had the 10 days paternity leave. So they decided that Mr. Van Wyk would take 6 months unpaid leave. And, as we can all understand, that obviously took a massive strain on their finances and the career prospects. So because of the challenges that they faced, they felt like this was discriminatory and it impaired the dignity that they had as a parental unit, hence their approach to the High Court.
And this approach to the High Court then went to the Constitutional Court?
Correct.
And what did the Constitutional Court, in short, find specifically on the challenge to the constitutionality of Section 25?
So the Con Court essentially aligned with the High Court. They found that the Basic Conditions of Employment Act and the corresponding sections of the Unemployment Insurance Fund Act are unconstitutional. The reasons for this were many, but in essence, the Con Court found that there was no justification for the law to differentiate between different classes of parents and children. So what this means was, as the law stood at that time, what we knew as maternity leave, which was the 4 months, and the paternity leave of 10 days. And that leave is now going to be called parental leave because the Con Court was of the view that it should be equal across the genders. And also we need to give fathers an equal opportunity to be part and parcel, of the nurturing and upbringing of the children's lives and for them not to be secondary parents.
Unathi, the Constitutional Court has declared Section 25 of the Basic Conditions of Employment Act, as well as the corresponding provisions of the Unemployment Insurance Fund Act, as unconstitutional. Where to from now?
Okay, so the Con Court has provided an interim order, and that means that during the period that Parliament has been given to fix the legislation, there is a way in which the Con Court has given us to read those particular sections that are affected. Parliament has been given 3 years to fix the legislation. And the reason why this is so is, obviously there's a lot of impact when it comes to amending legislation, and Parliament needs time, firstly, to fix it properly, make sure that the wording is correct so everyone is on the same page, to notify the necessary departments, and also to deal with the practical issues such as the reporting, which the Con Court, provided that the parent employees need to do.
All right. So the Con Court has, in essence, then amended Section 25.
Correct.
And when do those amendments come into effect?
So the amendments are effective as of date of judgment, and the date of the judgment was the 3rd of October 2025, and then Parliament has 3 years from the date of the judgment to fix the legislation.
Right. So let's then look at these amendments, because these amendments would have to now be put in place by employers.
Correct.
All right. So you did mention maternity leave is no longer maternity leave, it's parental leave.
Yes.
So is there no longer now a distinction between female and male employees when
Correct.
it comes to maternity leave?
Yes. So the Con Court covered a lot, and I think we're going to try to summarize it, obviously, because, it's important for everyone to understand. So in the case of a single employed employee or one parent who is employed, they are going to be entitled to 4 months parental leave. In the instance of both parents being employed, they are then entitled to 4 months and 10 days. In the instance of adoptive parents, if there is a single adoptive parent, they are entitled to 4 months leave. If the adoptive or the order relating to the adoption of the child covers 2 parents, then they're entitled to 4 months and 10 days. In the instance of surrogacy, if there is a single parent, they are entitled to 4 months leave. If the instance of surrogacy involves both parents who are employed, they are entitled to 4 months and 10 days.
Okay, so let's just take that a little bit slower. So a single parent or one party to a parental relationship that is employed, they're entitled to 4 months maternity leave.
Correct.
If there are 2 parties to the parental relationship and they're both employed, they're entitled to
4 months,
10 days. In aggregate, 4 months and 10 days.
Yes.
And that will then apply to if there's 2 adoptive parents and if there are 2 commissioning parents.
Yes.
They're entitled to 4 months, 10 days.
Yes.
Now, in a case where there's 2 parents or parties to this parental relationship, how does the section or has the Concord guided how they are to take this 4 months, 10 days maternity leave?
Yes. So the guidance that the Concord provided was in the instance of the parties being in agreement, they need to ensure that the period that a birth mother was given for the recovery relating to pregnancy is going to be included in the 4 months and 10 days. The remainder of that, so to simplify it, let's say 4 months, 10 days, minus the 10 weeks that a birth mother needs for recovery from birth. That remainder is divided by agreement between both parents. In the instance that there is disagreement between the parents, then the 10 weeks is still deducted because, naturally a birthing mother needs recovery time. The remainder is then apportioned as equally as possible down the middle between both parents. However, we don't yet have clarity on how the apportionment is done, but practically for these situations, it would be done by the employers, which is why it is important for employees to report and notify the employer accordingly.
All right. So the Concord did not interfere with a birth mother's 4-week period prior to birth
and 6 weeks,
6 weeks
post-pregnancy.
So if there are 2 parties to the parental relationship, we have in aggregate 4 months, 10 days. However, if I'm the biological mom and I've taken 4 weeks pre-birth and 6 weeks post-birth, that 10-week period then gets deducted from the 4 months, 10 days.
Correct.
And then I can agree with the other party to the parental relationship how we then take the remainder.
Yes. I think it's important for us to remember that as much as this judgment is progressive, naturally a birthing mother has physical implications that arise from pregnancy, and the court was cognizant of that, yes. Which is why those periods are still included and they haven't been taken away, because biologically a father employee would not need that recovery time.
Yes. All right. So coming back then to the in aggregate of 4 months, 10 days, as parties to this parental relationship, am I then entitled to take 2 months of the 3.5 months, and then the other party takes the remainder month?
So when dividing or splitting the leave, it's important for both parties to remember that the court has said that the parties can either take the leave concurrently or consecutively. Again, to simplify it, it means that the parties must take their leave in a single sequence of consecutive days. So you can't approach it using a hop approach. So you can't do 2 weeks on, 2 weeks off, 2 weeks on, 2 weeks off. It's either you take it as 2 months and 1 month, or, the 1 month, 2 month, but it has to be in a single sequence.
Then in respect of commissioning parents and adoptive parents, this 10-week period or this 4-week, 6-week doesn't apply. So we will, as parents, then have the full 4 months, 10 days.
Correct. Because for commissioning or surrogacy and adoptive parents, there isn't that physical aspect to deal with because they haven't actually physically given birth.
Okay, so just on that note, where's this 10 days come from?
So the 10 days is from the paternity leave as we knew it at that time. The court didn't want to take that away because it would have been unfair. So we have the 4 months from the traditional maternity leave. Then we have the 10 days from the traditional paternity leave, which would give us the 4 months, 10 days of parental leave.
To wrap things up, Unathi, what would you recommend employers to do now?
So it's important for employees to remember that as of the date of the ConCourt order, their policies need to meet constitutional muster. So they need to make sure that they go back to the drawing board. If their policies are aligned with what the ConCourt has provided, then great. But most employers were going to find that their policies are short and they need to amend those policies accordingly. However, it is important for employers to keep in mind that the changes made to the policies need to be communicated to the employees. And this becomes important because there are reporting obligations for employees. So everyone needs to be on the same page. Practically, employers are also dealing with a situation where they are going to have the male sector of the employee workforce out of work potentially longer than they would have originally have planned. And this is going to be something that is, quite a major shift for employers. And that also needs to be borne in mind for employers as to how they manage operations, which is why reviewing policies is incredibly important.
Okay. Well, thank you, Unathi.
Thank you, Deirdre.
That wraps up this episode. It's an incredibly interesting, dynamic area of the law, and we do recommend that employers take time to read the judgment and seek advice on reviewing of their policies. Thank you. Until next time, bye-bye.